In this immigration law update video, I want to look at a recent case which summarises the principles to be applied in Article 8 cases. In these videos, what I'm trying to do is give you a quick summary of case law, statutory and policy developments. Of course, if you need a more detailed seminar, sign up to one of my upcoming events with HJT training, MBL seminars or the solicitors group. Now, the case I want to look at today is called GM Sri Lanka and the Secretary of State for the Home Department, 2019 EWCA Civ 1630, and it's from the 4th of October 2019. And in this case, the appellant had entered into a relationship with another Sri Lankan national. She at the time was a student in the United Kingdom and had student leave. He had discretionary leave under the legacy scheme. And the couple had had 2 children by the time the case came before the tribunal. I think they also had discretionary leave at the time. The tribunal dismissed the appeal and gave little weight to the family life, relying on section 117B of the 2002 Act. They're the statutory Article 8 considerations that must be looked at in all cases. The appellant appealed to the Court of Appeal and the case came before the Court of Appeal. And Lord Justice Green has given a really helpful judgment which summarises the principles to be applied in Article 8 cases. Now, by the time the case came to the Court of Appeal, the husband and the children had been granted settlement, indefinite leave to remain, and the couple had had a 3rd child who was a British citizen. The appeal was successful before the Court of Appeal, and because there was now a British child which hadn't been considered by the Secretary of State, the case was, rather than remitted back to the tribunal, remitted back to the Secretary of State. And of course, with the existence of a British child, section 117B6 would apply, which would give a very strong case. But let's look at the judgment, and I'm going to give you the key parts of the judgment because as immigration practitioners, you're going to want to cite from this judgment in your representations, in your grounds of appeal, in your skeleton arguments, and this should give you some helpful meat when making your submissions. So Lord Justice Green summarises the general principles applying in the consideration of the proportionality test from paragraph 25 onwards, and he gives sort of 6 preliminary observations. I'm going to jump to the 3rd at paragraph 29, and this is about proportionality. He says this: 3rd, the test for an assessment outside the IR, that's the immigration rules, is whether a fair balance is struck between competing public and private interests. This is a proportionality test, and he cites there Aguiarco and Hesham Ali, key cases from the Supreme Court, which you should have a look at. In order to ensure that references in the IR and in policy to a case having to be exceptional, in inverted commas, before leave to remain can be granted, are consistent with Article 8, they must be construed as not, and he's underlined not, imposing any incremental requirement over and above that arising out of the application of an Article 8 proportionality test. For instance, that there be some highly unusual or unique factor or feature. And again, he cites Aguiarco. So in assessing proportionality outside of the rules, it's not an exceptionality test. It shouldn't be a search for a unique or exceptional factor. It's a proportionality balance weighing the public interest against the private interests. Now, in some cases, the public interest will weigh very heavily and you'll need something special to outweigh it. But it's not an exceptionality test. It's a proportionality assessment. Just briefly, his 4th observation is that the decision maker must look at the circumstances of the individual case. That's paragraph 30. 31, that there's a need for proper evidence. So if you're advancing an insurmountable obstacles case, make sure you've got proper evidence showing what those obstacles are. And he gives us an example, the case of Madibo versus the Secretary of State, 2017 EWCA Civ 1949. And in that case, there just wasn't proper evidence showing the insurmountable obstacles. And his 6th observation at paragraph 32 is that the list of factors considered in a proportionality assessment is not closed. Now, one of the important things in this judgment he goes on to do is look at the rights that the Mr. in this case, and the children, the husband and the children, would have to give up if they were forced to return to Sri Lanka. That's at paragraphs 34 to 35. Now, they didn't have ILR at the time, they had DLR under the legacy scheme, but that was a pathway to settlement, and that therefore was relevant to the proportionality test. So that's really helpful, because often if somebody hasn't got ILR, their rights are sort of swept aside in a consideration of proportionality, but that's a really helpful part of the judgment. The Court of Appeal also go on to look at how the tribunal had sort of confused section 117b(4) and section 117b(5). They shouldn't have given little weight to the family life in this case, because they weren't unlawful when the relationship was created. They were precarious, but they weren't unlawful. Obviously, look at the Rupiah case in the Supreme Court for that. They also consider the interests of the children, the paramountcy of the interests of the children at paragraphs 42 to 45. And the final thing I want to look at is their consideration of insurmountable obstacles. Paragraph 47, insurmountable obstacles is the test under Appendix FM EX1B. If you meet that test, you satisfy the rules. If you don't, your application would fail. But in a proportionality assessment outside of the rules, paragraph 48 says that insurmountable obstacles is simply a relevant factor and is not the test. And sometimes decision makers, judges, will say, well, there's no insurmountable obstacles, there's nothing exceptional, your case fails. Well, that's the wrong approach. So GM is a really helpful case in summarising the law on Article 8 and reminding decision makers of the correct approach. You'll want to have a look at it when constructing your arguments. Another case that followed that was Lal and the Secretary of State, 2019 EWCA Civ 1925. That's the 8th of November 2019, which is also worth a look. I hope that was helpful.